How are you, sir?
Great. Good afternoon, everyone. It's an honor to be here alongside of our governor with so many of our state and local government and law enforcement leaders. Pleased to be here with Attorney General Maura Healey, our Secretary Dan Bennett, Cape and Islands District Attorney Michael O'Keefe, and many of his colleagues who will be speaking in a few minutes, and of course Commissioner Evans and many of our local members of law enforcement. I just want to say that today is an important day for us to take another step forward here in our Commonwealth relative to tamping down on violent crime, whether it's guns, drugs, human trafficking. There's obviously more that we can do. It's also a day that we can highlight collaboration. When you have leaders in our office working with the Attorney General, working with our district attorneys and members of the local law enforcement, we are demonstrating to the communities across our Commonwealth that we will do everything that we can together to make sure that this Commonwealth is safe. It is our first priority in government to do so. One of the things that our administration did early on was to reestablish the Governor's Council to address sexual assault and domestic violence. And we included the Attorney General and our district attorneys in this effort. They've been incredible members of the team helping inform us on policies and budgeting. We've also been able to work with our colonel of the state police in launching the high-risk unit, which is focused on collaboration, not only with local law enforcement, but with our federal partners as well, in developing a response model to survivors of human trafficking. And just this past year, we were able to sign into law, working closely with our legislative colleagues, the requirement to preserve evidence in a rape kit to now match the statute of limitations with the crime of rape. And today we're filing an important piece of legislation. It's a major update to fight these areas of crime. It's like we're fighting it with one arm tied behind our back, and it's time that the Commonwealth update its laws, become much more modern, and use technology to do what's needed to keep our communities and our citizens safe. With that, I'd like to turn it over to our governor to make his remarks about the details of this bill.
Thank you, Lieutenant Governor, and thanks very much to the folks behind me here for their participation and collaboration on this initiative. I said upstairs when we were talking about it that this is sort of the third or fourth trip to the plate for a lot of folks who've been trying to update this statute since the late 1960s, and the Attorney General pointed out to me that we've had a lot of people who've worked together and collaboratively on this to make sure that this legislation would have a great chance of finding its way through the process. I would argue this bill is simply a common sense proposal to substantially update the Commonwealth's Wiretap statute for the first time since it was written in 1968. For the record, in 1968 I was 12 years old, and Carl Yastrzemski was my favorite baseball player. That was a very long time ago. There are many things that have changed around how we communicate and how we live since then. Technology, the kinds of criminal threats we deal with, and the nature of how people communicate a lot of information are all things that have changed dramatically since the late 1960s. And that statute that's currently on the books, by all accounts, has significantly hindered law enforcement's ability to investigate and solve some of Massachusetts' most difficult cases. The bill, as I said, is meant to modernize state law to allow law enforcement to more effectively do their jobs and use available technology to investigate some of the most heinous and violent crimes. And the legislation is very specific about which kinds of crimes folks in law enforcement would take before a magistrate for review. Things like gang-related homicides, murder or manslaughter, rape, human trafficking, weapons trafficking, drug offenses involving trafficking, manufacturing, or distribution, witness intimidation, civil rights violations causing bodily injury, use or possession of explosives or chemical or radiological or biological weapons. Now, in the last 6 years, in 2011 and 2014, the Massachusetts Supreme Judicial Court twice suppressed recordings of incriminating statements made by violent murder suspects, citing a need to update this particular statute to prevent the loss of such critical evidence in the future. This bill will also expand the list of applicable crimes or designated offenses for the first time since 1968, including illegal use, possession, theft, transfer, or trafficking of firearms, including machine guns or silencers, money laundering, enterprise crime, certain illegal gambling offenses, violations of the intimidation statute, or crimes involving the manufacture or dissemination of child pornography. All of us believe that modernizing this statute will give law enforcement the tools and flexibility that they need to investigate and solve crimes and threats in the 21st century. We look forward to working with our colleagues in the legislature, the law enforcement community, and others to make these critical updates a reality. It's now my pleasure to introduce Maura Healey, the state's Attorney General. She has been a terrific collaborator, partner, and leader on a variety of issues over the course of her term in the AG's office, but I've been especially pleased to have been able to work with her on the opioid crisis and the opioid epidemic, and am particularly impressed with the leadership she has shown on human trafficking, domestic violence, and a whole series of other issues. Madam Attorney General.
Thank you, Governor. Thank you very much, Governor Baker. I want to thank you and Lieutenant Governor Polito, Secretary Dan Bennett, and your colleagues in the administration for your work on this legislation. And I think it has been a terrific example of collaboration, the work that we can do and must do together in government. I also want to thank our colleagues in law enforcement, the many district attorneys represented here today, the police chiefs as well, for their partnership in this effort. As the governor said, this is a law that was passed in the late 1960s, and so much has changed. The technology that we use to communicate and that criminals use to do their work has changed drastically. In 1968, we didn't have cell phones, we didn't have text messages, we didn't have instant messaging, and that's what today is all about. Not only is this an effort to update and modernize the laws to give us the tools that we need to be able to do our work in investigating and holding accountable those who need to be held accountable, it's also a recognition of what our Supreme Judicial Court has signaled for a while now, that the nature and the structure and the shape of criminal activity and organized criminal enterprises has changed over time, and we need the tools in law enforcement to be able to confront that. The existing law made it hard to use wiretaps to investigate homicides, gangs, human trafficking, narcotics rings, and other serious violent crimes. So our office has long recognized that this is an important issue. We need to update these statutes to match the organizations and the infrastructure we face and fight across this state. And that's what we have here in today's bill, updates to the statute that will assist law enforcement to better investigate the most challenging crimes without compromising the strong protections for civil liberties and civil rights that are also central to our office's work. I want to thank the team in my office for their significant contributions on this effort, and I want to again thank the many partners standing here around me today for your work on this, and I want to thank again the governor and the administration. We look forward to working together in advocacy to get this over the finish line, to give us the tools that we need to be able to better protect and serve the communities across the state. Thank you.
Good morning. I'm District Attorney Michael O'Keefe from the Cape and Islands, and I'm here representing all of the district attorneys, many of whom are standing behind me. In 2011, the Chief Justice of the SJC, in a concurring opinion in Commonwealth versus Tavares, suggested that, and I quote, "Electronic surveillance is unavailable to investigate and prosecute the hundreds of shootings and killings in Massachusetts, which are among the most difficult crimes to solve and prosecute, using more traditional means of investigation," end quote. The court went on to say that if the legislature wishes to avoid this result, it could amend the statute. And as the governor has said, a statute last amended in 1968, when much of today's technology was not even in existence. The state's 11 district attorneys are sensitive, as is the governor and the attorney general, to the balance which we in a free society must have between a citizen's right to privacy and the responsibility that government has to protect its citizens from crime, particularly violent crime. And we feel that this statute strikes that balance. It maintains all of the hurdles that prosecutors must clear to seek a warrant under the statute, and among them are only the district attorney or the attorney general may authorize an application under this statute. The police investigator must demonstrate probable cause that a designated offense is the focus of the investigation. It must be shown that normal investigative techniques have been tried and failed to solve the crime. Police must clearly disclose the basis or source of their information, and only a superior court judge can approve an application. Interceptions are limited by statute in their duration. Only under these narrowly drawn circumstances and with prior judicial approval may electronic surveillance occur. With this limited but overdue revision, we can further stalled investigations into the Commonwealth's most serious crimes. We are grateful to Governor Baker and Attorney General for their support of this bill. Thank you.
Good afternoon. I'd like to thank the Governor, Lieutenant Governor, the Attorney General, and my fellow chiefs, DA Dan Conley, and everyone's here. Obviously, this statute is very beneficial to us in the city. You know, we deal with a lot of gang issues in our city. You know, last year we had 45 homicides, and to have this statute for us to use to investigate is key. You know, I remember a case back in 2010, Jaycon Brown, who was killed at 944 Parker Street. You know, we used the wiretap statute at that time against HBOC, trying to prove they were organized crime, and that was so instrumental in solving that cases. And to have this statute will help us, especially when a lot of people don't want to come forward, and that's one of the frustrations we have. So this will be an effective tool. You know, we used it with the federal government's help to take down MS-13 and 18th Street a year ago, to take down Mozart Street. The wiretap provision was effective, Columbia Road. And so this will be an effective tool to let us work with our district attorneys to you know, become more effective at solving these homicides. It's a great tool, not only with homicides and gang activity, but you know, now we face the threat of terrorism, not only in our cities but across the nation, civil rights violations, and more importantly, going after the gun runners. You know, already this year I think we have close to 250 guns, and to have this type of ability to use this technology, we can make this city, this Commonwealth, a lot safer place to live in. So I just want to thank the Governor. I know Mayor Walsh is very supportive of this legislation. I think it will make all of us in our Commonwealth that much safer and get rid of especially some of the unnecessary violence that we see. So thank you all.
Questions on this?
You mentioned the previous attempts to update this statute. What makes this legislation different from those previous attempts?
This one's going to pass.
Why is that? What's going to?
I can't speak to necessarily what what happened the previous times. What I can tell you is that the changes in technology with which both the Lieutenant Governor, the Attorney General, and the DA and the Commissioner all talked about is a very big deal and a really important issue. The second is the legislation is pretty prescriptive about which types of circumstances and situations you can use this for. Third, we're not talking about changing the process here. You're still going to have to go before a magistrate. You're still going to have to demonstrate you've exhausted available means prior to making that case. The magistrate is still going to have to rule on whether or not, in fact, they agree with you. And the final thing I would say is, we have some real-life experience here, especially with the terrorism question. I mean, if under the current statute, if people had gone to a judge and said that they were concerned about information that they had gathered revolving or surrounding a threat to bomb the Boston Marathon, under the current statute, they would not have been able to get a wiretap. And I think in some ways we should acknowledge the fact that the world has changed in many ways. And this is a modest but significant and appropriate adjustment to the current tools that are available to folks in law enforcement. And as everybody up here has said, nobody's talking about changing the fundamental process here that's in place. Everybody's still going to have to go before a judge, still going to have to make the case. And they will only be able to do it within the confines of the areas that are permitted under the statute. But we are limiting our capacity to keep people safe here in Massachusetts if we don't take the fact that a lot's happened since 1968 more seriously and make some of these relatively modest adjustments that can have big positive impact for people.
But Governor, why did it take so long? I mean, you're in a situation where you have to draft legislation and present it to lawmakers here. You know what
Yep.
the pushback is in advance, so why did it take so long?
I really can't speak to what happened previously. I mean, it's not always easy to know why a particular piece of legislation succeeds or a particular piece fails. What I can say, and I thought the Attorney General put it well when we were talking about this upstairs, people have worked this pretty hard through a lot of different perspectives and points of view to try to craft something that we believe we can get accomplished legislatively. And certainly all of us and many others are going to work pretty hard to see if we can't get this done in this session.
Do people feel like any changes to this would be, I guess, giving away a sense of civil rights?
Well, I think the big question about this is always around surveillance, and we all respect that. And I think that's why the legislation was very specific about which kinds of circumstances and situations you could use this type of technology for, and didn't do anything to change the existing process with respect to the requirements associated with the threshold you have to climb over when you go before a magistrate to make this happen. But when you have our Supreme Judicial Court and the Chief Justice both saying that the current law is an impediment to investigatory practice and justice here in the Commonwealth, that's a pretty significant development.
So your office worked with the Attorney General's office on
Yep.
this and drafting the legislation
Yep.
together?
Do you have make any changes to the way the public uses this or might be held culpable? I'm thinking about people who monitor the police on a cell phone video or something like that. Wiretapping is a phrase that gets brought up in those situations. Anything that the public could be on the hook for?
This one's going to go above my pay grade, so we're going to get the prosecutors in here.
You
Yeah.
don't need to go any. And the governor, well put on all those answers. And I believe that this is the right change to make at the right time. And part of it's also borne out by our experience. I mean, the fact of the matter is, we're in a different time and place from where we were with the Winter Hill era, and the nature of crime has changed considerably over the last 20 years. And we know directly through our experience in combating human trafficking, the opioid crisis, that this is part and parcel of the work that we need to do. And I'm very comfortable from a civil liberties perspective that the right protections, the constitutional protections remain in place. We're just acknowledging, as the governor suggested, what needs to happen in terms of the scope of the offenses that we want to be able to have addressed through this appropriate investigatory tool. So our offices work together, all these offices work together to craft legislation that both does not compromise our obligations under the Constitution, state or federal, and also gives us the tools that we need to have in the toolbox to be able to do the work that we need to do.
Can you say more specifically, what were some of the impediments under the old legislation other than technology that has changed, or a specific case in which one of the DAs or the office
Talk about the
to try to get the wiretap and were rejected?
Well, there's two things. One, it doesn't touch at all the civil. with anything to do with the public's right to record. So that is not touched by the bill. The second thing is, the big impediment was you had to prove it was an organized crime situation, which took other situations. For instance, when the commissioner talked about gang situations, you couldn't always prove that a gang was organized crime. They were a group of people committing crimes. 4 or 5 people does not necessarily mean it's an organized crime situation, and the Attorney General said it absolutely right. The Winter Hill Gang was organized to commit crime. 4 or 5 people may be people committing crime, but that's an impediment. You can't get to the situation where you're going to be able to get a wiretap under those circumstances. You know a conversation is going to take place over the wire about how they murdered somebody, but you're not going to be able to tape it, even though that's the only alternative you have to prove that that murder took place. That's a significant impediment. The other thing that I think that the Attorney General and the Governor really worked hard on with the district attorneys was the fact of not taking every crime out of making it a crime that we're looking at. They took limited number of crimes, as the Governor said, the violent crimes, murder, rape, violation of civil rights, trafficking, and terrorism. And those type of crimes are the ones that are taken out of organized crime. Other crimes aren't. And we also went to the legislature and talked to them ahead of time about why this bill would be something that they could look at. That doesn't mean we looked for approval, but as Governor Baker has done time and time again, and Lieutenant Governor Polito, we look to the legislators as partners, not as adversaries.
What were the concerns they expressed to you? What previous efforts have failed?
Civil rights, exactly what you said before. Are we protecting the public civil rights? And it was what the governor talked about. Judges, Superior Court judges, looking and making sure these approved. And nothing was taken away from those Superior Court judges. They're very comfortable, and they've looked at probable cause, making sure that you had reliable informants, making sure that there were solid police departments like the ones behind us today, like the state police, the transit police, Lowell, Worcester, Boston, Haverhill, Chelsea. Good police departments like that. You know, that's when you've worked in 3 different counties as a district attorney, you get to know the chiefs. But that's why.
How much of this is about vocal communication? Are we talking about text messages, email, social media, Twitter?
That's what the Attorney General, the Lieutenant Governor, and the Governor were talking about, modernizing it. It's about all those things, because things have changed over the last, since 1968. And my favorite player was George Scott, because he hit taters.
Thanks. I would prefer to think of it as collaborating.
Do you feel as if you still are going to have a little bit of one arm tied behind your back on this now, that you don't really, do you fully have what you need at this point?
I think this is, the answer to that is yes. We believe, all of us believe, that this would be a significant step up from where we are now in terms of our ability to keep people safe. But the other thing I would say is none of us here is looking to create issues with respect to surveillance and civil rights. And that's why we did nothing to change the process you actually have to go through to get a warrant. All we really did was say we wanted to create some categories that are defined for which, in certain circumstances, law enforcement could go talk to a magistrate about it. I mean, the Tsarnaev brothers is as good an example as any. They weren't, quote, organized crime. So if you had concerns about this and you wanted to get the ability to get a wiretap because you had probable cause and you'd exhausted a variety of other means to pursue this, people couldn't have done that under the current statute. They would be able to do it under this one because terrorism and bombing is listed as a particular category.
Are you taking off-topic questions?
We will, sure.
Governor, you're not saying that this could have prevented.
I'm saying that they couldn't have gotten a warrant, or they couldn't have gotten a wiretap under that circumstance because it wasn't organized crime.